We welcome today James Edwards, who is a fellow at Worcester College in Oxford and associate professor at the university. He's come to talk to us about the political morality of criminal law. James.
Great. Thanks very much, Andrew, for the introduction. And thanks very much for inviting me. It's a real pleasure to be here. So, what I thought I'd do is I would start with a bit of background about the paper before I get into what I'm trying to do and give you some of the arguments that are contained in there. I won't be able to talk about everything by any means. So the background is that I have a general interest in the question of what criminal law is for, what the general justification of this body of law really is. The equivalent question's been asked about punishment for a long time. When Hart uses the term the general justifying aim, he's talking about punishment. Less has been said about the general justifying aim of criminal law, maybe because people assume it's punitive, but that's not obvious. So that's one interest of mine that led me in this direction. And the second one is perhaps slightly more embarrassing. It's the number of stories I came across in the purveyors of doom that are the English tabloids about people who, as they put it, take the law into their own hands. You can find these stories all over the pages of these publications. There are individuals who do this kind of stuff. The Bromley Batman is a well-known example who goes around fighting crime on the streets of southeast London. There are groups, so when people started dressing up as scary clowns, it didn't take long for a group called clown hunters to emerge. Clown hunters go around doing some pretty chilling stuff, actually. If you look on YouTube, you can find some worrying examples of what they take to be an appropriate response to suspected crime. So there's this group. There was until recently an app called Vigilante, which you could get via the Apple Store, which would send you information about crime that was taking place at the time, so that you could go and get involved and do something. That was recently taken down because of worries that it might encourage people to act. So all of these things are going on. This made me, aside from a sort of moral fascination with it, think, well, there's a legal question here to think about, and I think it's this. So when we think about criminal law, we're not only thinking about a body of prohibitions, we're also thinking about a body of permissions. So when we criminalize theft, say, we prohibit theft, and we also permit various steps to be taken in response to it. So it's now permissible to arrest suspected thieves, certain types of search are now permissible, certain types of detention are now permissible, we can compel people to attend trial, we can lock them up as punishments. The entire set doesn't exist before you criminalise the wrong. Some constituents exist in some forms. There are types of detention that are acceptable outside the criminal law, types of punishment. But the specific set is created when we criminalise. And the specific set is not generally available. So the permissions in question are available to some people under certain conditions and not to others under those same conditions. So for instance, a police constable can lawfully search me if she's got reasonable grounds to suspect me of possessing stolen goods. I can be lawfully arrested by a police constable if there are reasonable grounds to suspect me of theft. I can be lawfully detained, at least in English law, for a day if the custody officer has reasonable grounds to think that's necessary to gather evidence. I can be compelled by force to attend trial in a criminal court, and I can be locked up for years by prison officers if I'm convicted and sentenced to prison. Now none of that goes for the Bromley Batman. Things are different for the Bromley Batman. He suspects me of theft. It's false imprisonment if he locks me up for a day to gather evidence. He can't use force to make me go to a trial at the Bromley Town Hall. Can't lock me up for years as a punishment. It's true that anyone can carry out an arrest under certain conditions. It's also true that anyone can use reasonable force to assist in bringing an arrest about. But even here, the conditions are narrower for the rest of us. So we are permitted to make arrests only if officials are not around to do so. If they can't do so, it's not practicable for them to do so. So there are narrower conditions available to us, even here. And this is what I have in mind in the paper when I talk about any symmetry that I'm interested in. So there's a set of permissions available in criminal law, made available when we criminalize. The set is available to some state officials, like police officers, some people to whom they delegate, like say private prison officers, but not to everyone. The question at the forefront of the paper is what justifies the asymmetry. By justifies, I mean what gives us a reason that's good enough. So that's the central question that's being asked. I mentioned at the very beginning an interest in this question about the general justification of criminal law. Why is that relevant here? Well, it seems to me at least that we can't hope to answer the question I just mentioned about the asymmetry unless we have some sense of what criminal law is for. You think about that in the following way. Any system of criminal law has to decide who gets to arrest, imprison, detain, etc. It's one of the things criminal law does, that allocates permissions to do these things. Where we have asymmetry, we have an allocation which puts the permissions mainly, or gives extensive extra permissions to one group and not to others. What justifies that? Well, we have to know something about what justifies the activities we're committing. And so we have to know something about what justifies having a body of law with all these features. We're going to have any hope of answering the question. So it seems to me that the general justification question is necessarily bound up in trying to answer the question about asymmetry. And so I have to say something about that too. So what I'm doing in the paper is pursuing in a way both these things. It's mainly taxonomical at this stage. It's mainly drawing distinctions between types of positions one might hold. I give some reasons to doubt certain positions and offer some reasons in favour of others. Those are very willing to concede are not conclusive. They're the beginnings of arguments that will eventually have to be spelt out in more depth. But these are the aims. Okay. So the paper quite early on takes a detour into distributive justice, and you might think of this as somewhat gratuitous detour. I hope it isn't. I made that detour because I think there are ideas in the literature there which are helpful to us, and I'm trying to understand asymmetry. So if you'll permit me a brief detour now orally into that debate, I think it has payoffs. So in the distributive justice literature, you see another kind of asymmetry. It's called dualism. And dualism is a view about the duties of justice that different people have. So what dualists think is that officials and private persons are very differently placed when it comes to duties to do distributive justice. So let me just say what I'm going to mean by officials. I mean people who occupy roles within major institutions and who have normative powers to change the relevant rules. Just think of private persons as people who lack those powers. If distributive justice requires equality, which many think it does, the dualist is going to say this. The dualist will say, officials have duties to make things more equal. Private persons don't. They don't have those duties. So imagine you're a private person with loads of money, and you can make things more equal by giving it to schools or hospitals. You may have some moral duties to do that. You do not have duties of distributive justice to do so. You don't have duties to make things more equal. Officials do. They're different things. That's not to say private persons have no relevant duties. They have duties to support just institutions, but they don't have duties to make things more just directly. That's the dualist view. Rawls was a dualist. There are many others. So why would you hold this view? It seems an odd view to hold. And there are two stories, basically, that one finds in the literature. So, one story essentially points to the other good things in life. It's one way to think about it. There's lots more in life than distributive justice. There's the rest of morality, there's living a good life for me. Trying to achieve distributive justice can be time-consuming, takes a lot of effort. If people have to do it in their private lives, that's going to crowd out the other good things in life, is the thought. So here's what we could do. We could delegate the job of doing distributive justice to someone else, let's say institutions and officials within those institutions. We can transfer our duties, if you like, externalize the burden, freeing us up to worry about the other good things in life. And that explains why we don't have the duties that officials have. That's one story, sometimes called the division of labour story. I like to think of it as a kind of efficiency story, not in an economist sense of efficiency, but in terms of efficiency of achieving lots of value. The idea is you can achieve more of lots of value this way, because the job of doing justice can be done by some people, the other good things in life can be achieved by us. So that's one story about why you might be a dualist. There's a different story, which has nothing to do with good things in life, it has to do with the problematic nature of institutions. So in this view, we start by looking at our institutions and we see that they're imposed on us, they're often coercive, we have a choice, and they have significant effects on people's lives. And that's thought to be problematic. The idea is that needs to be justified to those on whom the institutions are imposed. And so there's a problem when you get institutions, a new moral problem of justification. And some people think the way to provide the justification is to distribute things equally. Only then are institutions justified. And so doing distributive justice, distributing things equally, is essentially the solution to a problem created by institutions. And if that's true, then it's going to have to be the institutions that give us the equality. Because they're the ones that have to bear this burden of justifying themselves to each person. We don't in our private lives. Therefore, going to be obvious that the duties that exist are duties imposed on institutions. It's them that needs to be justified, not private actions. And so we led almost inevitably by that line of thought to dualism. It's simply not possible for me by donating money to schools and hospitals to solve the particular moral problem that distributive justice is all about on this view. So this view is endorsed by A.J. Julius and also in a paper called The Problem of Global Justice by Nagel. This is a kind of impossibility explanation. It's only possible for some agents to solve it. So those are the two explanations of dualism: efficiency, impossibility. I think this is a helpful distinction for our thinking about asymmetry, for reasons I'll get to in a minute. So we can now turn back to that, right? So to the asymmetry that I'm interested in. It's a legal phenomenon. There are some permissions available to some state officials which aren't available to other people. I've already suggested if we want to explain this asymmetry, we want to justify it, we'll need to have some sense of why the relevant activities are worth engaging in. Why is it worth arresting people, detaining them, trying them, and punishing them in the first place? Okay. It seems to me there are two dimensions to answering that question. One I think of as functional. Right? We want to know what's the function of things like arrest, detention, trial, punishment. What function do they fulfill in criminal justice system? Second dimension is what kind of value do we realize by fulfilling those functions? Much more has been said about the functional question. And I distinguish a few views in the paper about the function that these activities fulfill. One is, just to give you an example, one is punitive, right? So the idea is all of the other activities, arrest, detention, trial, just paving the way to the imposition of punishment. That's what this is all about, ultimately. Michael Moore says the only function of the criminal law is doing just punishment at one point. But Moore is not the only one. Similar view is expressed by Andrew Ashworth and Lucian Zedner, who say the purpose of criminal law on the liberal view they favour is to sentence, censure people who've committed wrongs, not just a purpose, the purpose. This is a view that sees all the other things as moving us on towards punishment. One view about the functions. There are rival views. Some people think that's a mistake. Trial is not just a way of allowing us to accurately deliver punishment. Trials have intrinsic value of their own. They call people to answer. They get people to give accounts of themselves that they have reasons to give. So this is a view that John Gardner and Anthony Duff hold. They think, John Gardner says explicitly at one point, even if we got rid of the punishments, we'd have reason to keep the trials. The trials have their own value, right? Getting people to answer for themselves. Just a reason, not decisive reason, but some reason. Call that a curial view. And then you could say, well, look, these views are all wrong. Both of these views suggest that we should give priority to something, to punishment, to trial. Maybe these activities are really all on a par, and it's all of this is about prevention. When we ask what justifies any of these activities, it's just prevention. And if we could prevent just as well without bothering with trials and punishments, we'd have no reason to do so. Some suggested in Hart's work on the criminal law, this is what he thinks, that the positive reasons for having a criminal law are all punitive.
Or preventive.
Sorry, preventive, yeah. Not all preventive. They're just constraints that sometimes apply. That's the functional, the range of views you might have on the functional question. There's a cross-cutting distinction, which is a distinction in the kind of value that we realise by fulfilling these functions. And this I think helps us with the asymmetry question most of all. So in the paper I distinguish between personal and impersonal goods. Okay, and what I have in mind there is that there are some goods only certain agents can achieve. So think about promise. It's good to keep promises, only the promise maker can do the keeping. Other people can make it more likely, you'll keep your promise, they can't keep it for you. Distinguished from that, something like protecting people against harm. In principle, anyone can do that. That's an impersonal value. Now, once we grant that distinction, if we do, we might then think that there's going to be the following possibility, which is that there are goods that only the state can achieve, via its officials and perhaps via delegates. It's going to be a personal value that's personal to the state. Call it essentially public. If there are goods like that, we might then think about the following line of thought. We might think, these goods solve some moral problem that can't be solved any other way. And this alone will justify engaging in the activities we've been talking about: arrest, detention, trial, punishment. This alone. And that's why we get the asymmetry, right? Because people who are not officials or delegates in the state simply can't deliver these goods. That's what it means for them to be essentially public. So if they alone justify the relevant activities, it's no surprise that private persons are not permitted to engage in them. And this would be an impossibility explanation of the asymmetry, right? It's just not possible for private persons to deliver the goods that justify doing things like arrest, detention, trial, punishment, etc. So that's one view about asymmetry. Here's a second view. Forget essentially public goods. There are lots of really important goods that are just hard to achieve without a high cost. And maybe the reason we have this asymmetry is because it's just the least imperfect way we have of achieving these goods that others could in principle achieve. Just the least imperfect delivery mechanism we have. That's what justifies having the asymmetry. This is what you could call an efficiency explanation, because it's again a matter of achieving as much value as we can at a lower cost. And that says nothing yet, of course, about exactly what these goods are. It just says that they're not essentially public. It leaves open the further question. So I think some people think if you endorse efficiency, you're utilitarian or something like this. And it's just simply not true. The efficiency view doesn't tell you whether what's intrinsically valuable is just happiness or preference satisfaction. Perfectly consistent with saying that, say, retributive justice is of intrinsic value. What the efficiency view says is if that's what justifies engaging in certain activities, then the reason to put those activities in the hands of certain people is that we get more of that good at a lower cost than we would if we did things another way. But the good there can be retributive justice if you like, or it can be something else. So there's no commitment to any wider moral theory implicit in this. So in the rest of the paper, having set things up in that way, and having set these up as the candidate explanations of the asymmetry, I talk about some versions, because so far these are really skeletons of particular views. They can be filled out in different ways. And so I turn to impossibility, which is the idea that the justification for these activities is found in essentially public goods. And I consider some different versions of that view. Right? So one is a kind of communitarian version that Anthony Duff endorses, and another is supposedly a Kantian version that Malcolm Thorburn in the criminal law context and Arthur Ripstein more generally endorse. Let me just say a little bit about this version, this second version, because I'll give you an example of what the impossibility story might look like. So what Ripstein and Thorburn think, roughly speaking, is this. They think in the absence of law, generally, and criminal law in particular, we're in a situation of comprehensive dependence on others. People might be very nice, they might be very generous, they might be very kind, but you depend on them for all that. A bit like a slave depends on a very benevolent master. And law changes things, they think. Right? Once you get law, and once you get law that's coercively enforced, you're no longer in this situation of dependence. You now have enforceable rights against others, which make you independent of other people. Now, let's say we think that's true. It won't get us to impossibility yet. But here's another idea we might add. We might say, and also, if the person doing the coercing is just another private individual, then all that does is introduce another form of dependence. They're just dependent on the person doing the coercing. So the coercer has to be special. They have to be capable of speaking for all of us and on behalf of us all. Because then they don't make any particular one of us dependent on any particular other. They make all of us independent of each other. And the only agent who can do that is the state. Only the state can speak on behalf of us all. Solving this moral problem, right, making us independent of each other, one might say, is what justifies things like arresting, detaining, trying and punishing people, and that alone. That means the only people who are justified in doing it are state officials, possibly their delegates. And so that's an impossibility explanation of the asymmetry, because we've got no grounds for permitting private people to engage in these activities. That's one unpacking of the impossibility account. So it's not the view that I tend to take. In the paper I give a couple of reasons to doubt it. I'll just briefly mention. So one is a general suspicion by essentially public goods. We need an explanation of why some goods can only be achieved by state entities or delegates. I hinted at one already, right? One explanation is only they can speak for all of us, or on our behalf. And I think there's a worry in the way that this is often thought to be almost an obvious point. Because everything depends, pretty obviously, on what's required to be able to speak on behalf of everyone or in their names. And very little is said about this. So you can imagine this being interpreted in a more thin or a thicker way. So the thin way just says, look, I act on behalf of someone and in their name. If I am motivated to promote their interests, or if I present myself as doing so. But obviously, if that's all that's required, then anyone can do it. It's not going to mark out the state as in any way unique. They might even say, oh, that's not what we mean. To act on behalf of someone in their name, it's not a matter of purely of motivation or presentation. It's something like you've been authorized, in some act of authorization. But then, of course, one wants to know what's the relevant act. Is it voting? None of everyone votes. Is it paying tax? Is it staying in the jurisdiction? Well-known problems with the idea that we somehow consent to government by staying in the jurisdiction, and they go back at least to Hume. So we need to hear a lot more about this requirement before we could accept a story that uses that requirement to mark a state out as unique. But I think that there's a more serious worry. So the more serious worry is this. The impossibility explanation requires that only essentially public goods can justify the activities made asymmetrically available. Why only? Because if it's not only those, then we don't yet know why private persons can't sometimes engage in irrelevant activities. Right? But why only? Why only these particular goods? It's not obvious. And I think the idea that it's only these goods comes from a certain way of thinking about institutions and the people who occupy roles within them. I think that's a suspicion. Not much is said about this. But I think the idea is this. So we think about institutions and we think about what special jobs they have to do for us. And once we've answered those questions, then that tells us what role occupants within the institutions, let's call them officials, should do. So we've got our state institutions, they've got a special job of making us independent, and so people within the institutions ought to do things that make us independent. The kind of line of thought. But that looks to me, again, problematic. So, for one thing, the fact that an institution has a special job to do doesn't exhaust the jobs it has to do. I think, why not think institutions have common functions, shared functions, as well as distinctive ones? So people often say things like, well, criminal law's unique function is to punish, and then move very quickly to the idea that that's its only function. Or criminal law's unique function is to call people to account, and then move very quickly to the idea that that's its only function. And that's surely a mistake. Shared functions might even be the most important. And so take the function of preventing bad things from happening. So a shared function that criminal law, for instance, has with other bodies of law might well be the most important function. So I think there's a problematic move here. And the other problematic thing, I think, is to think we should start with institutions rather than thinking about the people who occupy them. So I would tend to think we should think about things the other way around. We should start with the thought that there are people who are going to act when these institutions do things. And with the thought that these people don't magically cease to be subject to morality when they occupy their official roles. That's not to say roles can't make a difference. It's just to say, to the extent that they do, we need a moral argument for the difference they make. So if we're going to say that people should only, when they step into the role of judge, do justice between the parties, we need to explain why it's so important to do that particular moral task, and why other moral reasons that judges have get excluded or outweighed. Think about a similar idea for lawmakers. So let's say it's true that lawmakers have this special task of making people independent. Well, the fact that they're people suggests they also have other moral concerns. They don't magically cease to have them just because they occupy a role. One of the other moral concerns they surely have is protecting people against harm, which is something anybody can do, notice it's not essentially public good. Including people who can't be made independent, of course, people with very serious disabilities. The moral task of protecting them too. We can't just get the state out of this task by just saying, well, the special task of the state is to make people independent. Even if that was true, there will still be all these other tasks that the state has just in virtue of the fact that it's acting via people. How does this matter here? Well, these other goods may well be capable of justifying things like arrest, detention, trial, and punishment. If they are, we don't yet have a story about why only state officials should be permitted to engage in those activities. So again, I say these are just doubts, right? These are not decisive, but they strike me as worries about positions which say the only way to justify certain activities is via essentially public goods. Okay, let me now just say something about the view that seems to me better. Okay, so this is a kind of efficiency view as I've described it. We account for asymmetry not by pointing to essentially public goods, but by pointing to goods that others might in principle achieve. So how does this story go? I'll just try and unpack it in, let's say, 3 steps. Okay, so we start with the functional question. We start with the question, what function do activities like arrest, detention, trial, punishment fulfill? And here I think we should distinguish between the primary and the secondary. We should acknowledge that primary functions of criminal law are the preventive ones. These are the things we have most reason to want from the criminal law. Fewer murders, fewer rapes, fewer thefts, fewer robberies. Criminal law surely isn't indifferent between the world in which there are 10,000 robbers, all of whom are punished, and the world in which there are 100 robbers, all of whom are punished. We want it to help us achieve the second one instead of the first. That's its primary function. But that doesn't mean we have to go for the pure preventive view and think it's just all about prevention. Secondary functions too, and these can include discharging duties people have in virtue of wrongdoing. I don't want to take a specific position about the content of those duties. There are loads of positions out there. People think wrongdoers have duties to answer, to regret, to protect, to suffer. Let's just accept that there are some such duties. Perfectly happy to say that one of the secondary functions of the criminal law is to take steps to make it more likely that people will discharge those duties. So that's the functional question. Second step, what value do those functions give us? And what value does fulfilling those functions give us? Not an essentially public good, it looks to me. Why do we want to prevent crime? The obvious answer is we prevent people being harmed and we prevent people being wronged. Anyone might in principle do the preventing. What about the secondary functions? Getting people to give answers, getting people to regret. Again, anyone might in principle make it more likely that they will. So these are not essentially public goods. That leaves us with the third step. How do we get asymmetry from this? Because if anybody could in principle do it, why would we not have permissions which extend far beyond state officials and their delegates? And the answer, it seems to me, is that this would be in many ways problematic were we to do without asymmetry, were we to change the set permissions available. And I suggest in the paper we can see that by just reversing it, by imagining a case in which state officials are not permitted to engage in these activities and private people are. And I suggest a long list of problems that we might then face, that we have reason to think we would face. Imagine state officials are not permitted to engage in any of these activities. We immediately lose a quite valuable division of labour, to go back to the dualist discussion from earlier, in which we can get on with our lives while other people, namely officials, go about tracking down wrongdoers, preventing wrongs, preventing harm, getting answers, and all this stuff. And there are numerous other problems. We would think we would get a lot of error. We'd have all kinds of coordination problems. One's ability to get criminal justice would come to term even more than it does now, inequalities of wealth and power. You might say, well, okay, let's do this. Let's introduce dual channels, right? Permissions for private persons and permissions for officials alongside one another. But this is going to also lead to its share of problems, and coordination is another issue. We want to punish people proportionately to their wrongdoing. It's going to be very difficult to do. Just to say nothing of corruption worries about the kind of reasons for which people might exercise these permissions. And that's to say nothing of escalation problems, right? So if I go about punishing people I think have wronged me, maybe those people, the people I've punished are often not going to be very happy about this, they're often going to retaliate. There's a whole risk of a kind of downward spiral and a kind of Kit Wellner's helpfully discussed. Now none of this, I should say, none of this is to say that like public officials are somehow angelic or without their many vices. That's not the idea. The idea is things would be even worse if we change the rules in the direction of abandoning the asymmetry, and that's all you need on this to justify keeping those rules. People sometimes object, what about the one private person who is alone able to do something about a crime? Because for some reason state officials are just really poorly placed. Doesn't that show that we shouldn't have a general prohibition on, say, private people imprisoning people or forcing them to come to trial? But no, it doesn't, right? We evaluate rules by reference to the effects of the rules. So, no dogs in the restaurant, which Brett Shower's favourite example in his book on rules. What's the justification of the rule? That it reduces disturbance in the restaurant. Imagine someone comes along and says, here's my placid dog, and my dog will not disturb anyone. Let's say they're right. It doesn't mean that suddenly show that no dogs in the restaurant is the wrong rule to have. Of course it doesn't. Right? We know that rules are over-inclusive relative to their background justification. It's part of what it is for them to be rules. What matters is whether the underlying justification is best served by the exceptionless rule or by a rule that builds in an exception. And if we had a rule that says no dogs in the restaurant unless your dog is placid, well, we have good reason to think there'd be lots of mistakes, because people would think their dogs were going to cause no disturbance, and actually they would. And these are very strong reasons, these kind of risks of error, or just outright abuse from people who just say, I'll just exploit the exception. These are very good reasons to stick with the absolute rule. And the same kind of story can be told in the asymmetry case. Sure, there's the odd person who can do the job better in a given case. That's not sufficient to show we should have exceptions to asymmetry. What we need is a case that looks at the effects of those rules. And it looks to me like if we get rid of asymmetry, we have a serious problem of error and abuse of the kind I just mentioned, which is a good reason not to grant exceptions. Let me just mention, to finish, one other exception. People often say this is undue, this isn't political enough, this story you've told. You've told an efficiency-based story, it's not sufficiently political. Anthony Duff makes this claim. To which I'm inclined to reply, well, if sufficiently political means must incorporate essentially public goods, then that begs the question in favour of a view that does, which is the view I'm arguing against. If sufficiently political means pays attention to facts about politics, then surely the efficiency view does that. It takes into account the relative position, relative expertise, relative resources of public officials. This is like without more, not a satisfactory approach. So as I say, I'm inclined towards the sufficiency view. I've tried to sketch a version of it. I haven't given a decisive argument for it. But my sense is that it's the stronger of the competitors that I've outlined here. So as yet, I'm not inclined to abandon it. Perhaps you can persuade me I should do so. But I think I should stop there.